Now we're going to be shifting from our first educational speaker to our second educational speaker, who is none other than Elsa W. Smith. And Elsa is the founder of the law offices of Elsa W. Smith, LLC, a proud minority and woman-owned business. And the thing that stands out in Elsa's bio that has become a motto that I've seen so far from her is empowering women through estate planning. So her specialties are estate planning and wills, trust, and probate law. So we are in for a truly wonderful professional who's going to guide us through estate planning and legacy. Elsa Smith, when you are ready, the floor is yours.
Thank you so much, Lauren. And I'm going to go ahead and share my screen. Wonderful. And if Ellen, if you would be kind enough to give me a thumbs up that you can see my title. Excellent. Thank you so much. Good afternoon, everyone. She leads, she speaks, and thank you for inviting me back to present to your organization. I'm honored and humbled, particularly because of today's occasion. It is more than your regular meeting. You are giving honor, giving space, celebrating the life of one of your dear members who, interestingly enough, before I came on today, I did my own little research online, and I found the same video that was shared during the tribute today. So I got to see and to experience at least 5 or 6 minutes of the amazingness of Gwen. And she, I would have loved to have known her. I would have loved to have known her because just by that brief video, I felt her energy and her passion. So for that and so many reasons, I'm honored to be with you today. As you can see from my title slide, the title of this presentation is going to be Estate Planning for Women. The time to protect your health and wealth is now. And I want you to focus on that last word, now. Now is all we have. Now is all that we can control. And throughout this presentation, I want you to remember the pricelessness of now and the power that each of us has in the now. You've probably read a number of things about me. Here they are on the title, on the slide. Yes, I own an estate planning practice in Annapolis, in the state of Maryland. Of course, I have over 20 years of experience as a lawyer. The slide also shows a few of the recent accolades in estate planning that I've won. And by the way, something that's not on there, I'm also the parent of a rescue dog who is now about 12 or 13 years old. Another thing about me. So as I typically do in my presentations, I have a special offer for those of you who are attending today, and as my gift to you for the gift of your attention, my way of saying thank you. So please stay tuned. I always like to give everyone a roadmap. So here it is. First, we're going to start off with my promises, my commitments to you. Next, we're going to talk about things that you need to be concerned about. And these are particularly focused on women. Then I'm going to talk about Ashley. Ashley is not her actual name, but it is representative of an individual that I had the pleasure of serving. Next, we're going to talk about practical tools to protect your health, your loved ones, and your legacy. Then we'll talk about that special offer I mentioned. And then lastly, we'll finish out with questions and answers. So here are my promises to you. I promise that to help you overcome the fear of planning for the unexpected and the feeling of overwhelm. I want to help you create stability for loved ones in times of loss. And I also want you to be empowered to leave a legacy of success for your family. Now, here are a few things that we as women, I said you, but we really all of us need to be concerned about. Women are expected to outlive men by 5 years on average. And I believe that's according to the World Health Organization statistics. Compared to men, women are expected to have longer retirement periods as a result, which means that you're going to need to have a larger nest egg or to have some other source of income to last through retirement. Women are more likely to be custodial parents and serve as a caregiver to senior parents. And then just so you know, 6 out of 10 adults don't have a will. I believe that's according to an AARP statistics. So keep those things in mind as you're thinking about, estate planning and what you need to do to get your affairs in order. So I mentioned that we were going to talk about Ashley. Quick story. For this presentation, the woman in the photo represents this woman, Ashley, and so many women like her who I have been blessed to be able to help. Now, as a single mom, Ashley was afraid that her daughter would not, if Ashley became disabled, or heaven forbid, if she passed away. Ashley remembered her own childhood. Her father died when she was very young. She remembered her mother feeling distraught and overwhelmed because the death was unexpected. There was no life insurance or even a will. It was all very confusing for Ashley's mom. And relatives, were asked to pitch in what they could to pay for the funeral. And even that process was stressful. Ashley never shared this with her mother, but she was scared that they wouldn't be able to get by without her dad and his ability to generate income. She never wanted to feel that fear ever again. And more importantly, she never wanted that for her daughter. So it's in that context that we're going to talk about tools to protect your health, your loved ones, and your legacy. And we're going to talk about advanced directives, powers of attorney, trusts, and then we're going to lastly talk about wills. So advanced directives. Few aspects of advanced directives. One, you name a healthcare agent. There's a second part, at least in Maryland, that's known as a living will. And the important thing about advanced directives is that you have the right to refuse certain treatments. So an advanced directive allows you to decide who you want to make healthcare decisions for you when you are unable to do so yourself. As I said, in Maryland, the advanced directive has 2 parts. Part 1 is where you name the healthcare agent, and it describes the powers that the healthcare agent has. And then part 2 is known as a living will. And this section is important because it identifies 3 end-of-life or near end-of-life scenarios. 1, where death is imminent. 2, if you're in what's known as a persistent vegetative state, and 3, when you're in what's called an end stage condition. And in each of those scenarios, you are asked to identify what types of life-sustaining treatment you want or don't want. And this is important for a number of reasons. One, it's because it gives your loved ones peace of mind that they know what your wishes are. But 2, it forces you to really focus on your mortality, and that's something that most of us, really are loath to do. We don't want to think about it. We avoid it. And this form actually gets you to memorialize those desires on paper. Now, unless a written living will says otherwise, or advance directive says otherwise, it takes effect when the attending physician and another doctor certify in writing that a patient is not able to make an informed decision about their health care. An advance directive speaks for you if you are unable to, and helps make sure that your religious and personal beliefs will be respected. It's a useful legal document for an adult of any age to plan for future healthcare needs. Now, no one is required to have an advance directive, but it is smart to think ahead and make a plan now. To make your advance directive valid, it needs to be signed by you in the presence of 2 witnesses who will also sign that document. If you name a healthcare agent, make sure that the healthcare agent is not one of your 2 witnesses. Maryland law does not require that the advance directive be notarized. You should give a copy of your advance directive to your doctor, who will keep it in your medical file, and to others whom you trust to have it available if and when needed. And by the way, copies are just as valid as originals. So more about advance directives, and here are some questions that I hear often. Oops. If I am young and healthy, do I need an advance directive? If I'm in poor health, do I need an advance directive? And if I've discussed my wishes about my healthcare decisions with my family, do I need an advance directive? In other words, is it enough that I've just, I talked about what I wanted with someone over breakfast or over lunch the other day? And the answer is a resounding yes. Of course, you need an advance directive. Why? Because it is, as I said, it's not about you so much. It's about your loved ones. It's about the people that are going to make decisions for you. You have to remember that, and when I'm having consultations with people, I need to bring them into this space. I need to help them visualize an instance where an advance directive would be required. You're coming back home, you're driving back home from a networking event or a cocktail party, and you are slammed by an 18-wheeler. Your car is completely destroyed, and you need to be airlifted to, say, John Hopkins shock trauma. Okay, and you are in critical condition. You are on life-sustaining treatment, and then the doctors manage to find your identification in your car. They manage to contact a loved one. That person rushes to the hospital, and what they come to find is the doctor telling them, Mr. or Mrs. So-and-so, we've done all that we can. You need to contact this patient's loved ones because they only have 24 to 48 hours to live. That is very real. that can happen. And that's why I pound the pavement. I just scream it from the top of my lungs that it's so important to have, at a minimum, this document, because in the shock, in the whirlwind that will be everything that happens while you're in that ICU critical care unit, that will be one thing that will give your loved ones a little peace of mind. The doctor can say, by the way, Elsa Smith did have a copy of her, we have a copy of her advance directive on file. And I noticed that she named so-and-so as her healthcare agent. That one document can give your loved ones peace of mind. Because remember, they're still going to be processing the fact that they may lose you. And life is and time is of the essence. Right. So I want you just to keep that in mind. That is very real. So now we're going to talk about powers of attorney. Now, a power of attorney is a legal document that allows someone else, who we call an attorney in fact, to make legal, financial, and personal decisions on your behalf. Powers of attorney can be helpful to older people, for example, and others who want to choose a trusted person to act on their behalf when they cannot. And again, as you see on the screen, it's important to appoint someone that you trust. And you're going to hear that from me over and over again. And something else you should know about the power of attorney is that it is only valid while you are alive. In Maryland, to create a power of attorney, you need to be at least 18 years of age. You need to intend to give the power to the person designated in that document. That's that attorney in fact. And you need to be mentally competent, which means you need to be able to understand the document that you're signing, the powers that are being granted, and which property is affected by the powers that you're granting. And again, I say that, and I have to underscore this, is that the power of attorney is only effective while you are alive. When someone dies, now we're talking about, was there a will? And we're going to talk about that in a minute. But the power of attorney is only valid while you're alive. Now we're going to turn over to trusts. Now, trusts have generally three individuals who are important, or players. There's the grantor, the trustee, and the beneficiary. Three words that I want you to be familiar with. So what's a trust? A trust is a way of holding property, and it involves the three individuals that you see on the screen, on the slide. The grantor, first person. Say if I decide to put my property into a trust, then I am called the grantor. I am granting that trust my property. If I have investments that I need to manage, I'm going to transfer ownership or title of those investments from myself to this trust, to this legal entity. The trustee, second player, is the person who will manage that property for the benefit of the third entity, the third player, which is the beneficiary. The trustee's job is to read that trust document that's been prepared and manage and distribute the content of that trust according to the terms. The beauty of a trust is that you can be both the grantor and the trustee while you are alive and while you have capacity. When you no longer have the capacity to manage your own affairs, then your successor or backup trustee, if it's easier for you to conceptualize it that way, your backup trustee will be the one to be in the prime position. a wonderful thing about a trust, and particularly a revocable living trust, is that it doesn't need to go through the probate process, the court process, which is very public. Trust is not typically part of the public record, so no one knows anything about who your beneficiaries are or what assets you're distributing. And it's usually recommended that you create a revocable living trust if it applies in your situation. You'd also have what's called a pour over will. So in case any property is mistakenly left out of that trust, the pour over will transfers those leftover assets to that trust. And after an estate planning attorney has had an opportunity to review all of your assets and discusses with you one-on-one in a confidential setting, then that attorney is able to make recommendations as to your particular situation, because not everyone needs a trust. But if you do, then an attorney can then break down the different types of trusts that exist and what's right for your particular situation. That's why it's not a good idea to kind of DIY it and just download some document that you find online. In our office, we give prospective clients an extensive online questionnaire, and that gives us a really good view, a robust view of that person's estate. In other words, their stuff, what they own, regardless of the size. Now let's talk about wills for a second. A will is a written legal document that states what you want done with your belongings, money, and other assets after you die, right? And three characteristics of a will are that there's a personal representative, you're allowed to name guardians, and then you get to say how you want your assets distributed, and you have options for charitable giving. So again, a will can include your wishes about what happens or who will care for any minor children. Those are your guardians. I've had, by the way, as an aside, I've had people ask me about holographic or handwritten wills and whether they are valid. In Maryland and the District of Columbia, courts do recognize them. However, they need to be written properly. If not, there's a chance that the courts will not recognize them as valid. So you run that risk. My recommendation is to always have a written, prepared will, preferably done by an estate planning professional. As I said, the will allows you to name a personal representative. You may also know the term as executor, and a lot of times they're used interchangeably. The personal representative is the person that's empowered by the court to settle your estate after your death. Now, let me pause here for a second. How does that happen? Because that's not always explained. If you have a wills-based protection strategy, right? If the will is the hub of your estate plan, the will needs to be presented to a court. A will still needs to go through the probate process. Probate is two things. One, it's the court validating the will, saying, okay, upon our review, this will is legal and it was executed in accordance with Maryland or District of Columbia law. And then the second thing, probate is the supervision of the orderly distribution of your assets. The court, with strict deadlines and so forth, wants to know what's in that estate to the penny, and is going to ensure that each of your beneficiaries receive what they're entitled to under the will. And if, by the way, if there was no will, then that's called dying intestate. Then the laws of your jurisdiction will apply as to who gets what from your estate. So why should you make a will? You get to decide who receives your estate, not the government. You can leave things to a spouse, children, friends, and charities that mean something to you. The requirements to make for a valid will is that you must be of sound mind, right? The will needs to be signed by two witnesses in your presence and the presence of each other. And by the way, a notary in the state of Maryland, a notary is not required. Since we're talking about wills, I want to go ahead and offer you a free resource. It's our free will preparation checklist, and it's actually quite handy to have, period, full stop. But if you're about to schedule a consultation with an estate planning professional, it's a good just kind of cheat sheet to give you an idea of like things you need to talk about right before you talk with that attorney. This checklist is going to ask you the right questions you need to answer beforehand. So how do you get it? You simply go to my website at elsawsmithlaw.com, go to the resources tab, and there you'll see a will preparation checklist in the drop down of resources. Like I said, it's absolutely free. Just put your name and email and you'll receive it instantly. You'll be able to download it instantly. Thank you so much, Ellen, for putting that in the chat. So I encourage each of you to access this free resource. I have a question for you. Are you ready? Are you ready to overcome the fear of planning for the unexpected and the feeling of overwhelm? Are you ready to create stability for loved ones in times of loss? Are you ready to be empowered to leave a legacy of success for your family? And then lastly, are you ready to do what it takes to protect your health and your wealth now, today? Let's remember Ashley. Ashley was an example of a woman who took action. Now, with my legal experience and really love of estate planning and empowering women through estate planning, I've helped women like Ashley to conquer the fear of leaving their families unprotected and the fear of like a loss of control if something happens to them while they're alive. I've provided them with tools to ensure a good quality of life while they're alive and will protect what they've worked hard to build. And lastly, I've guided them to create a strategy that's going to leave a legacy of success for future generations. As I mentioned early in the presentation, I do have a special offer for you. And if you're ready to take action, I want you to take your cell phone out now and text "She Leads" to 55444 only during today's presentation and throughout the rest of the meeting. You'll receive 30% off of an estate planning consultation, which is normally valued at $400. If the consultation is confirmed, booked by Friday, May 27th of this year. So that'll be here before you know it. So "She Leads," text that to 55444. Now this cannot be combined with any other offer, any other promotion, and it's non-transferable. One per person, please. Again, the offer needs to be redeemed by May 27th, 2022. And if we'd be kind enough to put the "She Leads" to 55444 in the chat so everyone can take advantage of it. Madam Lauren or Ellen, that would be great while we're answering questions. Thank you so much. I'm going to allow a few minutes for questions because I imagine usually after my presentations, there's at least one or two questions that folks have, and it's always my pleasure to answer them. I do want to just thank you sincerely for your attention. I want to thank President Simmons, Dr. Oka, Maggie Serrano, thank you so much, the entire technical team, and the members of She Leads, She Speaks really for your hospitality and for the opportunity to present to you again. It's truly a pleasure. It was a joy connecting with you during this morning's networking session. And thank you just being so warm and welcoming. So I'm going to stop the share right now and turn it back over to Lauren.
You're on mute, Lauren.
Thank you. I know, I realized that as soon as it popped up. Thank you so much, Elsa, for that wonderful presentation. Very informative. And I actually had, we do have two questions in the chat. And I'll actually start with Lisa, Elsa. Lisa asks, for those members who do not live in Maryland, how can we obtain assistance with estate planning?
I'm licensed in the state of Maryland and the District of Columbia. If any of your members are perhaps in Virginia, they can still contact my office, and we'd be more than happy to make a referral. There are several firms that we make referrals to, so we'd be more than happy to assist in that regard.
Excellent. Thank you so much. And then I just had a quick question.
Please.
If you do a will early in life, I'm 32. Okay, I'm 32. If I were to do a will, I know, 32.
I'm 52. Okay, so you're a baby. But no, tell me.
Okay. Well, thank you. Most people say I'm not in my age group. They say we're old now. So, but if you do a will earlier in life, is there a certain amount of time you should be updating it, like annually or semi-annually? Like, how does that work if you do it, even if you did it with 30s, 50s, 60s, whenever? How often should you be updating these particular types of documentation? That's
an excellent question, Lauren. Thank you so much. What my advice is, and generally what the prevailing advice is among estate planning experts, is that you need to update your will whenever there is a life-changing event. Has there been a birth, a death, a divorce, an adoption? Did you acquire a significant piece of property? Aside from those major life events, it's a good idea to, as I say, just lay eyes on your plan every 2 to 3 years. And you may want to just schedule it on your birthday, if there's an anniversary or a special day each year that you want to use to say, you know what, I'm going to take that portfolio off the shelf or out of the fireproof safe, if that's where you keep it, and just flip through it. Are your beneficiaries current? Are they still alive? Are there changes that you need to make? Have you had a falling out with one of the beneficiaries and now you don't want to leave them as much as you wanted to leave them 15 years ago, right? And you know what? It's okay to make those changes. By the way, I am a former client, medical professional, had a will that she had done 15 years ago, right? And she wanted to leave a significant amount of her estate to her siblings, right? However, she didn't really have a great relationship with one of those siblings, right? So that troubled sibling, if you will, because of number of life issues, life complications that particular sibling had, that made their relationship strained, right? So when she came to me, she really came to me with a heavy heart about that. And I said, first of all, this is a safe space. So I need you to just share the details. Tell me why you didn't want to include that person then, and now why have you had a change of heart? And remember, we do not make estate planning decisions out of a guilt space, ever. Estate planning is to empower you. So you should never allow someone, and I know we're kind of going on a little bit beyond your question, but this is important for all the people on the call to hear. You never make a decision out of guilt. And, estate planning is about empowerment. These are your decisions, right? You don't do it because your family expects you to make a decision or assign someone to a particular role. In fact, I give my clients permission to say, name me as the bad guy. I give them permission to tell their family, I am standing in my truth. And this is a manifestation of that in my comprehensive estate plan. This is my statement, my declaration to the world about what I want my legacy to be. And if you need the backing of an attorney, you know, if you want me to be the person like, I blame her because she put all these crazy ideas about independence and empowerment. Oh my God, what radical ideas. Let me be that person, you know, because that's achieving me to help my mission, to get you to where the space that you need, deserve to be in. So short answer, every couple of years or on a major life event. And I know I went on a tangent, but I hope everybody can see that I'm kind of passionate about this. and I love what I do. So thank you.
It's a very good tangent. I'm here to absorb, and we are here to absorb as much knowledge as possible. So one question can lead to answering several other questions. We do have one more question in the chat from Sonia. I think we're still on time. I know I see Maggie, so I think we're still on time.
Oh, sorry.
Oh, no, it's fine. I always just try to keep an eye out for my fellow Shiros. But Sonia's asking, while her mother is alive, she thinks her word is more powerful over her body, Sonia's body, than her husband. It sounds strange. And she says, does she need this in writing? I guess based on her wishes.
Yes, you should always. So if I understand, so Sonia is concerned that her husband has more of an influence?
Sonia's concerned that her mother believes she has more power over her body than her husband would. So the mother thinks she takes precedence over the husband.
Oh, no. Yeah, no, husband, definitely. But this is a perfect example of why things need to be in writing, because, you know, people, particularly in very stressful situations, some may be well-meaning, some not, but you have that potential for conflict. And if you have like a situation here where you have a spouse and then you have a parent saying, well, you know, I carried her for 9 months, you know, I know exactly who, you know, what she wants or what, you know, whoa, I'm now the spouse. And yes, the doctors are going to ask the spouse, sorry, mom and dad, you know, but that's just the reality. But you can avoid all that conflict by having that advance directive, having something in writing to just tamp down the conflict and the noise.
Excellent, and thank you. That I'm sure that helps. I see a heart from Sonia, so that was more than helpful. Thank you so much, Elsa. Are there any more questions that anyone would like to ask? If you'd like to come off mute or drop your question in the chat, please do so. Taking a look, I'm not seeing any questions in the chat. And the Shiros or guests that have any questions that like to come off mute. Wait a few seconds.
While you're doing that, while you're looking, again, text She Leads to 55444. Take advantage of that limited offer for everybody who's on the call. And by the way, take advantage of the free resource I mentioned during the presentation.
Conversations and great questions, and also you don't look a day over 35 apparently. So
oh, bless you, my mother's jeans.
Which we all agree, you look fantastic.
Thank you.
Everything. All right, I think that's it from our Shiros and our guests. Thank you so much, Elsa. Please give her a virtual hand clap and give her various kudos in the chat, please. We really were in for a treat from both of our presenters. What fabulous education sessions coming out with so much knowledge in this club. This is a fantastic club.
This is my honor, and thank you again.